May I please your lordship? Lordship, I beg to mention for listing of a IA lordship for substitution on Monday lordship.
When?
Substitution petition lordship.
Monday.
Yes, lordship. Deep lordship.
May it please, Lordship. Lordship, I beg to mention for listing one I on Monday, Lordship. It was filed on 12/8 last Monday. Mass submission. May it please, your Lordship. So I play for listing of a CRP owner. I'm appearing for ASIDC owner. The order is against the eviction by Airport Authority. Maybe on listen on Friday only, day after tomorrow.
Possible.
21st Wednesday.
Is there any urgency?
Yes, sir, it's against an eviction order, Your Honor. Because I'm appearing for ASIDC and eviction order is by
You
Airport.
can
Authority.
take it up when the next date is fixed.
I'm not able to next, but maybe on the day after tomorrow, Your Honor. So there is an urgency, Your Honor, in this matter.
Can it be on Monday?
Not it permits, then I'll request for Friday, Your Honor.
Okay. Okay.
Oh, bless you.
May I please, your lordship? In item number 42, I am paying for adjournment for 2 weeks, your lordship. We want to file affidavit in opposition, but the respondents here is out of session for medical reason. I already informed the other side. It's
No, I'm appearing for the petitioner in this matter. I have no
Okay.
objections to that.
Any objection?
No objections, Lordship. They filed the affidavit with the file.
Okay, Mr. Your good name?
N. Thakuria for S. Sharma.
And Thakuria, learned counsel appearing on behalf of Mr. S. Sharma, learned counsel for the respondent with consent from the other side, press for listing the matter on.
After 2 weeks,
After 2 weeks, so as to enable him to file affidavit in opposition, where is accordingly allowed. Rest is the matter after 2 weeks.
Obliged.
Please, your lordship. I beg to mention item number 2, my lord. Kindly.
Item number
2.
2,
Kindly fix at 2 p.m., my lord.
2 p.m.
May I please, your lordship? I have filed one IA in April 15 of 23, which was filed on 24th July. 24th July.
When do you want?
This matter may kindly be listed on Monday.
Okay.
Wait, please, your lordship. If we for listing of this MFA and 2 MSc appeals, my lord, last listed in the year 2022, my lord. Next week, my lord, anytime, my lord.
Take a date from him.
one on 21st, one on 22nd.
Please, your lordship. Lordship, I beg to mention item number 40 with the consent of other side.
Item number 40.
40.
40. Your good name?
J. Gayan.
Ms. J. Gayon, learned counsel appearing on behalf of
On behalf of the S. Saraf. D. Saraf.
D. Saraf, learned counsel for the appellant with consent from the other side, press for listing the matter. When?
Chiveni.
After 1 week or 2 weeks?
After 1 week, your lordship, I am appearing on behalf of the respondents, your lordship.
1 week.
1 week.
Yes, lordship.
1 week. Mr. Ona, your good name?
M. Kaishap, your lordship.
MK?
M. Kaishap.
Mr. M. Kaishap, learned counsel for the respondent number 1 and 124.
1 to 4.
Submits that he has no objection. In view of above pair of Ms. Gayon is accordingly allowed. Rest is the matter after 1 week.
1 week.
1 week.
I'm opposed.
Obliged.
May I please, your lordship? It's for listing of a matter, your lordship. On
When?
Friday, your lordship.
Friday not possible.
On Monday, your lordship. Obliged.
Please, your lordship. Lordship, I beg to mention as CRP, your lordship, for orders, your lordship.
When?
On 28th or 27th, 27th or 28th, your lordship.
28.
Obliged.
May I please, lordship?
Hmm.
I beg to mention item number 51.
Item number
51.
51. Your good name?
S. Dollar. On behalf of J. Pine.
Ms. S. Dole, learned counsel appearing on behalf of Mr. J. Payne, learned counsel for the appellant. Press for listing the matter after 1 week.
Okay.
Lordship, I'm praying for listing a CRP matter.
When?
Next week, 21 or 22.
21.
Nice. But I'm paying for listing of one transfer petition.
When? Monday. Monday.
This was Friday, but if Monday is
On
Possible.
22nd only. 22nd.
May I please, your lordship. I beg to mention one RSA for listing on 22/8. Earlier, my lord, the matter has been raised before this
No,
honorable.
no, when do you want?
22 of 8.
22, possible.
I have filed, my lord, one
Take it
IFA.
on 27, the next day,
Oblige.
27.
Maybe. I
Yes.
have to mention item number 38. with concern of-
38.
With concern of the other seller.
You are for
B. Hussain on behalf of I. Talukdar.
Mr. P. Hussain, learned counsel appearing on behalf of Mr. I. Talukdar, learned counsel for the applicant with concern from the other side. Press for listing the matter after,
3 weeks lordship.
pardon,
3 weeks lordship.
3 weeks.
Sir.
Okay, clear a lot.
Oblige.
Lordship, I beg to mention for listing this IA for continuation of delay, your lordship.
When?
And notice has been issued on 20th, your lordship. 20. Oblige.
May I please your lordship? I want to mention item number 31.
Item number
31.
31.
Lordship, circle office report is not come today.
Pardon?
So matter may be come listed after 2 weeks.
You are for
Respondent. We are for respondent. Babul Gogoi.
your name?
Babul Gogoi, respondent.
No, your name, please. Miss so and so, learned counsel appearing on behalf of Mr. Your name is there in the cause list.
I am appearing on behalf of my senior lordship,
Who is your senior?
N. Talukdar.
Learned counsel appearing on behalf of Mr. N. Talukdar, learned conducting counsel for the respondent with consent from the other side. Press for listing the matter after. When?
2 weeks.
After
2 weeks.
2 weeks. Clear a lot. Did you inform the other side? Inform
Yes, lordship.
home.
My senior no. I don't know my senior.
এইটো পাৰ্টি কোন আছিলে গাংগুলী এই গাংগুলী Oh, we'll call the matter. You remain present in the court.
Oblige, lordship.
Items from daily list for motion, item number 1.
May I please, your lordship?
Yes.
In this case, my lord, plaintiff filed a suit for specific performance of contract along with a player, my lord, for agreement was for the agreement for sale, my lord, over lot of land of 5 lesser, my lord. In the plan, my lord, he paid for specific performance of contract and along with the alternative pair that money ticky may be passed for returning the advance money, my lord. In the WS, my lord, we have admitted that we have executed the sale deed, my lord. Thereafter, my lord, during the proceeding, my lord, we thought that, my lord, since we have admitted the execution of the agreement, my lord, we filed an application that the alternative pair which the plaintiff had made.
So,
We-
but you saw the WS
Yes, ma'am.
where you have admitted the fact so as to pronounce judgment by the
Yes.
trial court.
Page 34, my lord.
34.
34. In that, my lord, we have not, for the first pair, we have not admitted, my lord,
Then-
for execution of
then-
sale deed. For the alternative pair, my lord, alternative pair, my lord, may see, my lord, alternative pair is page 15, my lord. Alternative Dicky he has paid, my lord, plenty. Page 15, my lord.
Yes.
Page 15. One side, my lord.
No, that is there. There is no doubt about it. But in your written statement, where you have admitted the said fact, so as to pronounce judgment by the trial court,
That is specifically not admitted, my lord.
then
Then, my lord,
what
Yeah.
wrong with the order of the trial court?
Yes, my lord, that even if I do not admit in the WS, my lord, provision, my lord, order, my lord, 12, rule 6, my lord, says that at any time that admission can be made. my lord.
Show the provision.
Yes, my lord. Order 12, rule 6. Very well.
Hmm.
Judgment on admission, my lord. Where my admission of fact had been made either in pleading or otherwise, whether orally or in writing, the court may at any stage of the suit, either on the application of any party or of its own motion, and without waiting for the determination of any other question between the parties, make such order or give such judgment as it think fit, having regard to the such admission, my lord. In the application, we have made the admission, my lord, that we are ready to return the advance amount which he has claimed in the alternative pair, my lord.
Will issue notice.
Yes.
Pardon, is that?
M. Setia, my lord.
M. Setia, learned counsel for the petitioner. In this petition, under section 115 of the Code of Civil Procedure, the petitioner, Shri Vikran Barua, has put to challenge the correctness or otherwise of the order dated 6/7/2024 passed by the learned Civil Judge Junior Division number 4 Kamrup in Midje case number 561 of 2022. In title suit number 160 of 2022. It is to be noted here that by the impugned judgment on the impugned order, the learned trial court has dismissed the petition number 1102 of 2022 passed by the filed by the petitioner stroke defendant to pass a judgment and decree on admission as per order 12 rule 6 of the Code of Civil Procedure. Where is the petition and the documents placed on record? And also where is the impugned judge order dated 6/7/2024. Let notice be issued that this is returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Call for the scanned copy of the record. List the matter after 4 weeks.
In the manner proceeding maybe that because the cross examination is fixed on 9/9, my lord. If we proceed with the cross examination, my lord, that issue will be, my lord, proceeded, my lord. Because, my lord,
No, if at any stage of the proceeding that can be done, why staying of the proceeding is
because,
necessary?
my lord, this issue is decided, my lord, in my favor, then, my lord, whole suit will be, my lord, disposed of, my
No,
lord.
let the trial go on. In
Yes,
his,
my lord, if the trial is about to be going on, my lord.
how
whole
prejudice
suit is
will be caused to you?
Because, my lord, if that petition which I have filed, my lord, if that is decided in my
Don't-
favor, my lord, there will
That can be at any
only
step, we will see.
whole suit will be, my lord, disposed of, my lord.
Interim period of the petitioner will be considered on next date.
Item number 3.
For the petitioner, hearing Millard, the case is that we file a resolution Millard, there is resolution 1 of 23, and that is pending. And in this case, Millard, we file a Millard, meet J case number 2 of 23, and in that case, Millard, interim injunction was granted. And against that order, Millard, the respondent filed an appeal before the Millard, district judge, Millard, and that appeal, Millard, uh, disposed of one lot 29,524. That I have an next lot in excess 6, page 61. Whereby my lot, the order of the interim injunction lot that was set aside. Now the land is not taken by them, and actually it is our Pattal and Miller. We were in position, now they have forcefully taken position, and now they are trying to construct some structure. So my prayer rulership, the notice will be issued, and the structure of the land may not be changed till filling of the and that land is amounting to only 16 acre land. And interim injunction, your lordship, and see page 52, that was granted in my favor.
Page number 50.
Page 52, annexure 5 lot that was granted in my favor
Hmm.
at interim injunction order. And after hearing both the parties. Both parties are present with it.
Heard Mr. A. Rosit, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner, co-petitioners have put to challenge the correctness or otherwise of the judgment and order dated 29/5/2024, passed in Miss Appeal number 1 of 2024, passed by the learned District Judge Baksa. It is to be noted here that by the impugned judgment and order dated so and so, the learned District Judge Baksa has set aside the order dated 11/10/2023, passed in Miss J case number 2 of 2023, passed by the learned Civil Judge Senior Division Baksa. It is to be noted here that by the impugned order, no, by the order dated 11/10/2023, the learned Civil Judge Senior Division Baksa has granted injunction and restrained the opposite parties from erecting any permanent structure over the suit land and from changing the nature and character of the same till disposal of the suit. Peruse the petition and the grounds mentioned therein, and also peruse the impugned judgment and order dated 29/5/2024, passed by the learned District Judge Baksa, and also the order dated 11/10/2023, passed by the learned Civil Judge Senior Division Baksa in Mijay case number 2 of 2023. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Registrar will call for the record from the learned Court of Learned District Judge Baksa and also from the Civil Judge Senior Division Baksa until returnable date. The impugned order dated 29/5/2024, passed in Miss Appeal number 1 of 2024 by the learned District Judge Baksa extends state.
Item 4.
My lord, this is a petition which I preferred against an impugned order passed in disposing an application, my application under Order 7 Rule 10 of the CPC, my lords. My lords, may I have the list of dates? At internal Roman 4, my lords. My lords, the case in brief is this, that on 27/9/2021, the state government of Assam notified the Assam Tenancy Act 2021, my lords. Thereafter, I got into a memorandum of understanding with the respondent, my lords, where I let out my premises for a business purpose. Due to default of rent, my lords, I am seeking eviction of the gentleman. And he preferred a case for a suit for injunction against me, which is pending before the learned trial court, my lords. Their suit, my lords, if my lords has page 63.
So you saw the provision of Section 40 of Assam Tenancy Act 2021.
My lords.
Correct. Assam Tenancy Act.
My lords, a copy of the act is also in the petition. I'll just give your lordships the page number. It's also annexed at 234, my lords.
Not in all matters, the jurisdiction of civil court is barred.
My lords, only on the question of eviction, not on the question of ownership or title. That is the clarity which comes from Section 40 itself. What happens is, my lords, earlier there was an Assam Urban Rent Control Act, which was repealed by the Tenancy Act of 2021. In fact, my lords, the state government of Assam was the tip of the sword when it came to the model tenancy code for the entire country. We were the first state to notify it, in fact. Now, the issue is very simple, my lords. My case is that the jurisdiction of the learned civil court is expressly barred under the act. I had pled that specifically in my Order 7 Rule 10 for return of plate, my lords. Now, if my lordship see the impugned order, the reason for dismissing my application also is not tenable, my lords. My lords may have Roman 11, my lords. It starts at 10, but 11 is the effective paragraph, my lords, right on the very, it says, the learned trial court puts the onus on me to produce the notification of the state government notifying this act, my lords. I did so, my lords. Not only that, I went beyond the call of duty and I filed 3 separate RTIs from the before the Assam Legislative Assembly, the Secretariat, and also the Housing Department, my lords.
The notifications are available in the record.
The notifications are also available, my lords. I will just show your lordships the annexures as well. My lords, annexure 810. This starts at page number 262, goes through 295. 263 are the replies of the departments, my lords.
260?
263. And the interesting portion, this, my lords, is that the learned trial court does not even consider these RTI notifications, these RTI applications or their responses, my lords. They only rely upon a RTI application of the petitioner. I stand corrected, my lords, the plaintiff.
What is the reply?
263, my lords, may see the reply of the legislative department, legislative branch. My lords may have 264. It says with reference, and my lords, on number 1, the Tenancy Act 2021 was notified on 27th of September 2021 and published on 1st of October 2021 in the State Gazette by the Government of Assam. Copy of the Assam Gazette so and so is attached. My lords, the layering of the submission is a little different, my lords. If my lords may have page number 63, I'll show your lordships what is. My lords have it?
Okay.
Page 63, para 9, my lords. It is the specific case of the plaintiff that his case is.
Wait.
My lords.
Page number?
63, my lords. That's the copy of the plaint preferred by the plaintiff. Para number 9, my lords, he sets up his case specifically to state that the suit premises being situated in an urban area, the tenancy is governed by the Assam Urban Areas Rent Control Act of 1972. He is going under that specific provision of that act. There is.
So, when this act was repealed?
My lords, it was repealed on the date this, the Tenancy Act 2021 was notified effective 1st of October.
From that date?
From that day itself. And nowhere in the plaint, my lords, the averment is that they have actually approached the rent control, the rent control court also. My
Rent
lords,
control?
there is a rent control court which is constituted under the act. It is not the case of the plaintiff before the lower court that they ever approached the court as well. They are simply relying upon the fact that
Okay. Heard, Mr.
K. Khanna, my lords, with M. Das.
Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to silence. Petitioner Andrew Ahotu Sema has put to silence the correctness or otherwise of the order dated 17/2/2024 passed by the learned civil judge number 2 Kamrup and entitled suit number 151 of 2023, rejecting the application for return 2023. It is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition filed by the petitioner under orders 7 rule 10 of the Code of Civil Procedure for returning the plaint. The learned counsel for the petitioner submits that the respondent of the present petition has instituted a suit under Assam Rent Control Act. No, Assam Urban Area Rent Control Act 1972, but the same has been repealed by Assam Tenancy Act 2021. Referring to a reply of RTA application given by Legislative Department, Govt of Assam, the learned counsel for the petitioner submits that the Assam Tenancy Act 2021 was notified on 27 September 2021, published on 1st of October 2021 in the State Gazette by the Government of Assam. And as such, the suit filed by the respondent under the Assam Urban Area Land Control Act 1972 is not maintainable. The submission of Mr. So-and-so learned counsel for the petitioner needs further consideration. At this stage, notice be issued to the respondent returnable in 4 weeks. Step be taken by registered force with AD and also by usual process within a week from today. Till returnable date, operation of the impugned order dated 17/2/2024 stands state.
Grateful.
It's a lender tenant dispute, my lord. Petitioner before lordship is the defendant. He is the tenant, my lord. My lord, he was paying the rent in court. And my lord,
So what wrong with the order of the trial court?
the prayer is made for calling of the mistake cases that are the rent deposits, my lord.
But you have not mentioned the same in your written
Yes, my
statement.
lord, my written statement was filed in 2013. And
2000?
my written statement was filed in the year 2013, my lord. And these rent receipts are subsequent to that, my lord. But there are statements in my written statement that I am regularly paying the rent in the court, my lord. So that's why the prayer is made to call for all the, and I have deposited the, my lord, rent receipts, and there is also prayer to call for the mistake cases, my lord. Because from that only I can prove that I am paying the rent in the court, my lord.
So your prayer is only to call for the record of
Mistake
exhibit B18 to B82.
These are the mistake cases which are paid, my lord, subsequent to filing of the written statement. And I have also produced the, my lord, rent receipts. The court has refused to accept the rent receipts and says that this cannot be considered in the evidence. And my lord also rejected my prayer to call for mistake cases, my lord. Because if that cannot be,
Where is the impugned order?
that is at page 44, my lord. It starts from page 44.
Page number 30?
44, my lord. It starts from page 44. Relevant will be page 45, my lord, paragraph 5. That is the finding of the court. Finding is at page 45, paragraph 5.
Okay. Heard Mr. A.K. Gupta, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India. Now, in this petition, the petitioner, namely Om Prakash Agarwal, has put to challenge the correctness or otherwise of the order dated 15/6/2024 passed by the learned civil judge junior division number 2, Tinsukia, in title suit number 32 of 2010. It is to be noted here that by the impugned order dated so and so, the learned trial court has allowed a petition, partly allowed the petition number 487 of 2024 filed by the petitioner. It is also to be noted here that by petition number 487 2024, the petitioner has right for calling the record of depositing rent with the rent controller which are exhibited in the evidence in affidavit as exhibit B1 to B82. But the learned trial court has agreed to call for the record from exhibit B1 to B17, but rejected the pair in respect of calling the exhibits being B18 to B82, B18 to B82, on the ground that the said exhibits were not mentioned in the written statement filed by the present petitioner. Mr. Gupta, learned counsel for the petitioner, submits that in the written statement was filed earlier to the depositing of rent with the rent controller white exhibit B18 to B82, and as such, the same could not be mentioned in the written statement. And therefore, Mr. Gupta submits that the impugned order suffers from manifest illegality and therefore contended to set it aside. So far, it relates to dismissal of the pair of the petitioner in respect of calling the exhibits B18 to B82 from the rent controller Tinsukia. But having heard the submission of learned advocates, learned counsel for the petitioner, and I have carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 15/6/2024. And it appears that the learned trial court has allowed the pair of the petitioner who calling the rent cases in connection with exhibit B1 to B17, but it has but it did not allow to call for exhibit being B18 to B82. On the ground that the same were not mentioned in the written statement. And that the petitioner did not take the leave of the court to file the aforementioned copies. Pertaining to to file the copies of the treasury salon pertaining to exhibit B18 to B82. Having considered the submission of Mr. Gupta, learned counsel for the petitioner, and also considering the facts and circumstances on the record, this court is inclined to allow this petition. It is provided that the learned trial court shall call for the record pertaining to exhibit B18 to B82 from the Rand controller Tinsukia. In terms of above, this CRP stands at disposal. That this motion is itself.
But also observed, my lord, by the impugn order, the court has said, my lord, the exhibit B18 and B82 cannot be admitted in evidence, my lord. After rejecting my prayer,
And to admit the same in evidence.
Item number 6.
the page 46, my lord.
Which one?
My lord, item 5, my lord, lordship has allowed the prayer for calling for the record.
Yes.
But the trial court has also said that these exhibits cannot be admitted in evidence, my lord. That observation may be referred by.
Ordered it.
Okay, sure.
Item 6.
Please, Your Lordship. Sir, we have filed this revision challenging an order rejecting our prayer for amendment, my lord. My lord, the petitioner as plaintiff filed a suit for declaration of right title interest over a plot of land measuring around 14 bighas. Out of that 14 bighas, my lord, the defendant number 1 and 2 tried to encroach upon 5 bighas of land. So, when my lord, their claim is that my lord, they had purchased this land, these 5 bighas of land from defendant number 3. So when we filed this suit, we did not have any idea as to how the defendant number 3's husband had got the mutation. We simply thought that there was an illegal mutation, and on the basis of that illegal mutation, the defendant number 3's husband got mutation, and after that, after his death, his wife, that is the defendant number 3, had sold this land, that this 5 bighas of land, to defendant number 1.
You are the plaintiff.
I am the plaintiff. So when we filed the
So being the plaintiff, you are not aware of the execution of the
Yes.
sale deed number 4623 of
that,
69.
yes, they in their written statement took a plea that that is the plaintiff, had sold these 5 bighas of land to the husband of the defendant number 3. Why the registered sale deed executed in 1969? Yet we had no knowledge. We got to know about that only after filing of the written statement. Now, my lord, the thing is that if your lordship will kindly see the impugn order, my lord, the lower court was of the view that, my lord, we should have been more vigilant. My lord, that sale deed was not within our knowledge. We have not executed that sale deed, my lord. How come, my lord, the question of being vigilant will arise? My lord, that is why, my lord, we just simply seek an opportunity to incorporate that sale deed in our plan so that we can challenge it. If your lordship will kindly see the impugn order, the relevant portion, my lord, is at page number 41, at para number 4. The learned court below was of the opinion that we had already executed that deed and we were negligent enough not to bring it on record. But we are going to challenge it. We are totally denying about any execution of such sale deed. So if we do not get any opportunity to challenge it, my lord, that our entire suit will become futile. So that much, my lord. And regarding the question of prejudice, definitely they will get an opportunity to cross-examine us on this particular point. So, my lord, all these facts, my lord, must be placed before the court below so that it can be adjudicated in a proper manner. That much we have prayed for, but it was, my lord, summarily rejected, my lord, without even assigning any proper cause. So, my lord, the main reason, my lord, is a para number 4. It is also stated that the petitioner that the opposite parties have abstained from producing the aforesaid sale deed. Well, the sale deed which we have not even executed, where will be the question regarding production will arise? And that was not within our knowledge at the time of filing of the suit. Now, when it has been brought to our knowledge, simply we want to incorporate that particular fact.
No, it is stated that it was your own registered deed.
Yes, that
Where is the question
that
of
is their
not
plea,
knowing
madam.
about the same?
That is their plea. We simply thought that on the basis of some illegal mutation, the husband of the defendant number 3 had taken possession over that land. We did not know about any execution of sale deed. We are going to dispute it. We are going to deny it.
Okay, at this stage, we will issue notice.
Yes, madam, and madam, the case is at the stage of cross of PW. Madam, kindly some protection, madam. Otherwise, if the cross examination is done, then the entire matter will become futile.
How? How?
Because if the cross examination is done, then after that, madam, there is no question of amendment, madam. Now, at this point, if we can amend, then definitely they can cross examine us on this issue. That whether you had executed.
No, no. After the trial start,
Yes.
amendment cannot be allowed as
Yes.
per rule.
If there is sufficient cause is that, my lord, we did not know about this deed. When we came to know about this deed, we applied for a certified copy and we got the certificate.
Where is the ground for not knowing about your own deed, registered deed?
Yes.
Hmm?
But
So
we
trial
have
court has cited reason for the same
But that will
based on the decision of Supreme Court.
that will only when, my lord, we have admitted about the execution, my lord. We have not even admitted. My lord, we will not admit this execution, my lord. So we should be given an opportunity to challenge this deed. That much we have sought for, my lord. And once cross-examination is done, my lord, then there is no question of, my lord,
No,
incorporating. this.
already your terms over.
No, my lord.
Order 6, Rule 17.
Yes, sir. Proviso to Order 6, Rule 17, my lord, provided that no application for amendment shall be allowed after the trial has commenced unless the court comes to a conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial.
So, where is the diligence on your part? You saw it.
Because, my lord, that is the only thing, my lord, that we have no knowledge about the execution, my lord. If your lordship will kindly see the claim. At para number, my lord, 3. Page number 18. And for the first time, the plaintiff came to know that one Ramesh Chandra Uza, that is the husband of the defendant number 3, got the illegal mutation. We simply state about illegal mutation. If you had said that the illegal mutation was on the basis of a sale deed, then definitely there was some negligence on our part. In this case, we have.
Okay, we will issue notice, but no relief at this stage.
But
Let the other side appear. We will hear both the side. Thereafter, we will consider. Heard Mr. S. Das, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 15/7/2024, passed by the learned Civil Judge Senior Division Baksha in Mizje case number 2 of 2024, arising out of titles of number 13 of 2024. This to be noted here by impugn order dated so and so. The learned trial court has dismissed the petition filed by the petitioner for amendment of the plaint. Peruse the petition and the documents placed on record and also peruse the impugned order dated 15/7/2024. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post
Whereas
and
what
October
did we
result
fix also?
process within a week from today. Call for the scanned copy of the record from the learned trial court. And in view of the given facts and circumstances on the record, and also in view of the reason order being passed by the learned trial court in dismissing the petition of the petitioner, this court is not inclined to grant any interim protection at this stage. However, the same will be considered on appearance of the other party.
Can a short date be fixed, my lord? We'll take even dusty service, my lord.
After 4 weeks.
2 weeks.
2 weeks. Highly obliged.
Number seven.
Dusty service is also permitted.
Please allow me. By this petition, my lord, I have challenged the my lord, order dated 29/7, my lord, whereby rejected the amend of the plain, my lord, as well as my lord, evidence in chief, my lord. Kindly see, my lord, under Rule 6, 2017 petition page 52. And some, my lord, clerical mistake regarding date of, my lord, cause of action, my lord, and some portion of the my lord, line, my lord, drop in the plain, my lord.
Where is the impugn order?
Impugn order, kindly see, my lord, page 66. And operative portion, my lord, reason, my lord, page 70. Page 70. The suit is at the stage of cross-examination of PWs. Already on the basis of the suit, the defendant have submitted their written statement. Further, if the proposed amendment is allowed to be made, it will change the facts of which are already pleaded by the plaintiff regarding oral agreement for sale. Even the document which are sought to be faked are not a part of original suit of plaintiff.
You are reading page number 17 of 57.
70.
Yes, from which part?
My lord, second line, where this suit is at the stage of cross-examination of PWs, already on the basis of suit, the defendant have submitted their written statement. Further, if the proposed amendment is allowed to be made, it will change the facts which are already pleaded by the plaintiff regarding oral agreement for sale. Even the document which are sought to be fakes are not a part of the original suit of the plaintiff, which in the view of this court will cause prejudice to the defendant. And in the suit, already evidence on affidavit is filed by the plaintiff petitioner side. There is no mention in the petition why the proposed amendment has been sought, and same fact could not be introduced when the suit was originally filed. That due to that reason, my lord, the amendment petition rejected, my lord. It is a, my lord, ad inverted.
So
mistake, my
the
lord.
stage of amendment is over already.
My lord,
Hmm?
it is a, my lord, mistake, my lord, ad inverted mistake, my lord.
Can it be
It
corrected
can
at
be
this
corrected
stage?
at any stage, my lord.
Hmm?
It never changed the, my lord, nature and character of the suit, my lord. And that mentioned the cause of action, my lord, 10/9, my lord, which ought to have been, my lord, 10/8, my lord. And drop of few lines, my lord, regarding, my lord, receipt of amount, my lord. Part of the, my lord, the receipt amount, my lord. In the plain, my lord, generally stated that the defendant received the 10 lakhs, my lord. But part, my lord, payment, it was 5 lakhs in cash, my lord, and 5 lakhs in check amount, my lord, which are not, my lord, recorded in the plain, my lord. It never changed the case of the, my lord, nature and character of the suit, my lord.
So in view of the proviso to Rule 17
My lord,
of Order 6,
my lord.
so you have to show that in spite of due diligence, you could not raise the matter before the commencement of the trial.
My lord,
Show the reason.
and my lord, it is that a mistake, my lord, while drafting in the.
Can it be,
And
can
while,
the
my lord,
mistake is a ground?
My lord,
And then well, let the other side appear.
my lord, cross, my lord, on 3308, my lord.
All right, but the stage is already over.
My lord, till returnable date, my lord, is said, my lord, if the
No, no.
cross-examine, my lord, then, my lord, automatic, my lord, amendment, my lord. This
No, already the
petition
stage is
can
over.
Become infectious, my lord.
Heard Mr. K.R. Patkari, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 of the CPC. The petitioner has put to challenge the correctness or otherwise of the order dated 29/7/2024 passed by the learned civil judge, Senior Division Barbeta in Mizje case number 181 of 2023. In arising out of TS number 03 of 2022. It is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition filed by the petitioner for amendment of the plaint and evidence in chief under Order 6, Rule 17 of the Code of Civil Procedure, or no, Code of Civil Procedure Code. Peruse the petition and the documents placed on record, and also peruse the impugn order dated 29/7/2024. Let notice be issued to the respondent, returnable in 2 weeks. Step be taken by registered post with AD and also by usual process. Justice service is also permitted. Registry shall call for the scan copy of the record from the learned trial court. And since the stage of amendment is already over, and since the petitioner has failed to show any ground that, spite of due diligence, he could not raise the matter before commencement of the trial as required by proviso to section proviso to Rule 17 of Order 6. This court is not inclined to grant any interim stay at this stage. However, on appearance of the parties, other party, the court will consider this on appearance of the other party and receiving the record of the learned court below, the interim pair will be considered.
It may be section 29, my lord, 30, my lord, my lord.
Okay.
30, my lord, 29, my lord.
Obliged.
8.
Yes, Lord. Actually, in this case, plaintiff filed a petition for additional witnesses, Lordship, examining additional witnesses that was rejected. Lordship, kindly have a look at page 41.
Page
41.
31.
41.
Under whose provision you filed this application?
So it is a provision not mentioned, but it is actually under Order 16 Rule 13.
Order
16 Rule 13.
Order 16.
Lord.
Rule 1B.
Lordship. Sub-rule 3. Lordship, then your Lordship kindly come to page 43. That is rejected by the learned court below. On the ground that already he filed the name of 3 witnesses. One was cross Lordship, and other 2 he fails to face the cross Lordship, and it was dispensed.
No, you are referring to order 6 rule.
Lordship, order 16 rule, sub-rule.
Oh, yes, order 16 rule.
Rule 1, sub-rule 3 of rule 1.
Sub-rule
3, Lordship. I have also stated in my petition, Lordship, at page 4. There are 6.
So what is the ground? What is the cause?
Lordship, actually, he submitted name of 3 witnesses, but failed. One of the witnesses is bedridden. That's why he failed. To prove the case, Lordship, 2 more witnesses necessary to examine. That's why he made a present application, and that was rejected by the learned trial court.
No, earlier you did not file their name.
Yes, no,
List
not
in the list of
Lordship.
witnesses.
3 witnesses we have filed, and their chief also submitted under order 18 rule, full Lordship. But they failed to face the cross-examination due to one was dispensed with by the order dated Lordship 2/3/2023, and another by the order dated 4/4/2023. He was in a bedridden condition, so he failed to appear before the learned court below, Lordship. PW3. Lordship, kindly have a look at page 43. I have order passed by the learned trial court.
Page number
43. Type copy, Lordship.
yes.
Lordship, learned counsel for the defendant is showing objection to the prayer of the plaintiff side by stating that all the 3 PWs have failed filed their examination in chief, and the PW1 was cross-examined, whereas cross-examination of both PW2 and 3 were dispensed with due to deliberate delay on the part of the plaintiff. Peruse the case record, it is seen from the perusal that the ample opportunities have been given to the plaintiff side to cross-examine 2 and 3. Perusal of the case record also reveals that their cross-examination was pending since 17 to 2022, for which cross-examination of PW2 was dispensed with by order dated 2/3/2023, and PW4 by order dated 4/4/2023. The record itself shows that the plaintiff side deliberately delayed the proceeding in the instance. That's why it was rejected by fixing the date on 17/8/2014 for DW's Lordship. Lordship, petition also filed along with medical paper of the PW3 Lordship. Lordship.
No, instead of PW, earlier PW2 and 3, now you want to examine some other witnesses.
Lordship, some other 2. These 2 failed to appear before the court. That's why, Lordship, problem arises that much. They are unable, Lordship, in a bedridden condition PW3 who has
Heard Mr. Mazumdar, learned counsel for the petition. In this petition under Article 227 of the Constitution of India, read with Section 151 of the CPC. The petitioner, Sharifuddin Loskar, has put to challenge the correctness or otherwise of the order dated 4/7/2023 passed by the learned Civil Judge Junior Division Lakhipur Kasar in petition number 4/4 in the title suit number 1 of 2019. It is to be noted here that by petition number 4/4, the petitioner has prayed for allowing him to examine 2 more witnesses in place of PW 2 and 3 whose cross-examination were dispensed with by the learned trial court. And after hearing both the parties, the learned trial court has dismissed the petition. As the record reveals that the petitioner, being plaintiff, has deliberately delayed the proceeding of the suit. Mr. Mazumdar, learned counsel for the applicant submits that, the petitioner submits that PW2 and PW3, who were named in the list of witnesses and whose examination in chiefs were also filed before the learned trial court, could not be examined on account of their bedridden condition. And medical documents were also submitted before the learned trial court along with the petition. And instead of those 2 witnesses, the petitioner prays for according him permission to examine 2 other witnesses in place of PW 2 and 3. But the learned trial court has dismissed the same. And in order to establish the claim in the plaint, examination of the 2 witnesses are necessary in the interest of justice, and therefore Mr. Mazumdar has contended to allow the petition. But having heard the submission of learned advocates of learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on record and also perused the impugned order dated 4/7/2024 passed in petition number 4 of 4. It appears that the name of 2 witnesses as PW 2 and 3 were submitted in the list of witnesses and their examinations in chief were also filed. But on account of illness, the aforesaid 2 witnesses could not be examined. Could not be examined. Section order 16 Sub-rule 3 to Rule 1 provides that the court may, for reason to be recorded, permitted a party to call, whether by summoning through court or otherwise, any witness other than those whose name appears in the list referred to in Sub-rule 1 comma, if such party shows sufficient cause for the omission to mention the name of such witnesses in the said list. Here in this case, it appears that the petitioner has shown sufficient cause. That on account of the illness of PW2 and 3, they could not be cross-examined, for which their examination in shifts were dispensed with. It is the contention of Mr. Majumdar, learned counsel for the petitioner, that examination of 2 more witnesses are required in the interest of justice. But having considered above and also considering the relevant provision of law, this court is inclined to allow this petition. It is provided that the learned trial court shall allow the petitioner to examine 2 more witnesses. The list of, have you filed a list of those witnesses?
No, Lordship, that was rejected. Name was not given. Only application was filed, but it was rejected.
Name was not given. The list of, the names of those witnesses, those 2 witnesses within a period of, when the next date is fixed?
And Lordship, it is 17/8.
17/8. Before the next date of hearing. And thereafter the learned trial court shall proceed to hear and dispose of the suit in accordance with law. In terms of above, this CRP stands disposed of in the motion is itself.
Number 9 and 10,
Online.
that is for admission.
Made three questions. Just statutory appeal minor, that can be land acquisition appeal minor. Award was minor for 4 lakhs minor. Whereas the evidence was given minor, the compensation awarded nearby land minor, it was around 7 to 9 lakhs minor.
So what are the grounds?
Grounds minor and the evidence minor, the valuation of much higher branch minor. The valuation certificate was produced minor before as a evidence minor, it is around 9 lakhs per bigha. And it was reduced to 4 lakhs minor, therefore it's an enhancement minor, it's a regular appeal minor. Kindly produce the minor, page 14 minor. Page 14 of the appeal.
Yes,
Paragraph 20 and 21 minor.
yes.
PW2 has stated that as per the valuation certificate, the valuation should be fixed at 9,36,000. He is the valuer minor, and the independent evidence minor page, the next para minor 21. Nearby land minor, it was in another case where the acquisition of well minor, it was fixed at 7 lakhs minor. Therefore, the record should be called for minor.
Pardon me, sir.
Fill out it for us.
Learned counsel for the appellant and Mr. Gogoi.
T.R. Gogoi, Lordship.
Dear Gogoi,
Respondent number 1, Lordship.
learned counsel for the respondent number 1.
Lordship, yeah, I think DRDO, there are separate standing counsel for this department, Lordship. They may be also called for the hearing, Lordship. Respondent number 2. I am for respondent number 1.
That's all right. If anybody is available, inform him. Otherwise, we will issue notice.
Earlier it was issued, my lord, notice were issued, my lord, their council has appeared, my lord.
Okay. It is appeal under section 54 of the Land Acquisition Act 1954. Is directed against the judgment and decree dated 31/5/2017 passed by the learned district judge Kamrup Amingao in reference case number 20 of 2014, which in bracket old number 22 of 2013, arising out of LA case number 6 of 2009. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and order dated 31/5/2017. Admit. Let notice be issued to the respondents returnable in 4 weeks. Step upon respondent number 2 be taken by registered post with AD and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Mr. Gogoi, learned
May I please, Lordship?
government advocate.
Earlier notice were issued, my lord, today it is come for admission, my lord, notice were duly served upon the government and the DRDO, my lord.
Earlier,
Notice were issued, my lord.
when? This is listed for the first time today.
It,
Order dated, office note order dated 31/10/2022. The order was passed to take a fresh step to the respondent number 2, Lordship.
no, there subsequent, there was a limitation application, Lordship. In the earlier occasion, the limitation were disposed of. my lord. Mr. S.C. Kyle was appeared for DRDO.
No, this appeal is listed for the first time. But in the IA, the
I will
counsel for the respondent number 2 appeared.
appeared, Lordship. And we have served the copies and all, my lord, to the council.
Whether his name is reflected in the cause list
Name has
today.
not been reflected, my lord. They even filed the objection. in
Okay,
the
later on, Mr. Siladitya, learned counsel for the appellant submits that in respect of condonation of delay, the appellant has preferred one IA before this court, and in the said IA, delay was condoned, and one Mr. S.C. Kyle, learned
Standing counsel for DRDO.
standing counsel for the DRDO, had entered appearance. And as such, notice is not required to be issued. However, it appears that the name of Mr. Kyle is not reflected in the cause list. Recessal list the matter after call for record follow. Recessal call for the record from the learned trial court and list the matter after 4 weeks, reflecting the name of Mr. S.C. Kyle, standing counsel for the DRDO in the cause list. Same order in 50 also.
Yes, same, similar. Deeply obliged.
Lordship, GA Assam should be also be reflected in the court later.
GA Assam is reflected
Perhaps
in item number 9.
Lordship.
Okay.
Item 11.
May it please your lordship. Your lordship, before the appeal is admitted, IA number 691 of 2024 has to be disposed of. That is for modification and alteration of order dated. Order dated 31/2024. which was passed by Justice Malashri Nandi regarding the condonation of delay, Your Lordship.
What modification is necessary?
Your Lordship, respondent number 7 and 8, which is the owner and driver of the truck, they were struck off inadvertently, Your Lordship. And we have taken the ground of contributory negligence. So if the appeal is admitted, it will have an adverse effect.
Well, they are already they are already the party in the main appeal. Your Lordship may issue notice to the main appeal.
In which part of the order it is reflected to strike out their name?
My Lord, page
Your Lordship.
13 of the I. Last paragraph.
I number 691 of 2022. Page number 14, Your Lordship. Third paragraph.
So you were the applicant there.
Yes, Your Lordship.
So it was your submission.
Your Lordship, due to communication gap, we submitted that they are the necessary party. And yet they were struck down. So Your Lordship,
No,
modification.
it was done on the basis of your submission.
Yes,
Now, can you?
No, Your Lordship, there was misunderstanding.
Hmm?
Actually, there was a misunderstanding. They were necessary party.
Then on what basis you have submitted?
Your Lordship, actually we submitted that they were
Mhm.
necessary party, they cannot be struck down. But due to communication gap.
Okay, we will take it up at 2 o'clock.
Okay. Much of.
We obtain some instruction from the registry.
Okay.
Item 12.
Lordship, this is, as the first appeal is against the order by which I have sought for custody of my child, Lordship. So, first appeal, Your Lordship may admit and call for the LCR. There is no interim prayer also in this case.
Art Miss R. Sodri, learned counsel for the appellant. This appeal under section 47 of the Guardians and Ward Act 1890 is directed against the order dated 29/6/2024 passed by the learned principal judge Family Court Dhuburi in FC case FC Miss within bracket Z case number 08 of 2023. It is to be noted here that by the order dated 29/6/2024, the learned principal judge Family Court Dhuburi has dismissed the petition filed by the petitioner seeking by the appellant seeking custody of the minor son. Where is the petition? Where is the memo of appeal and the grounds mentioned therein, and also where is the impugned order dated so and so?
Page 32, Lordship.
Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AB and also by usual process. Within a week from today. Rest shall also call for the record from the learned trial court. List the matter after 4 weeks.
Yep, yep, yes.
Wait, please, Your Lordship. Like appellant before Your Lordship filed an title appeal. That was dismissed for default. Against
Dismissed
that,
for?
default, my lord. He filed an appeal.
Hmm.
That was dismissed for default. Against that, he filed a
case for restoration. That restoration petition was rejected, my lord. So, my lord, against that, I have filed this appeal. Your lordship would be pleased to turn to page 41. The impugn order. Yes. So, my lord, your last para, my lord, page 41. Upon perusal of record, it appears that appellant as well as his engaged counsel did not take any steps on so-and-so date. The relevant medical documents so-and-so, most of the documents are of the period which are required after dismissal of the title appeal. That apart, your lordship will mind it. That apart, the nature of ailment does not seem to be that serious, which require the bed rest or prevent any through mobile phone and with the learned engaged counsel. Moreover, the proceeding was not a trial proceeding. Meaning thereby, my lord, appellant's presence is not necessary. It is the advocate who looked into the case.
But it appears that on several occasions, neither the appellant nor his counsel appeared.
That is there, my lord. Your lordship just see my ground. I want to submit before your lordship. When an advocate is engaged, he is an advocate till the proceeding is completed or till he is determined with the leave of the court. That is order 3, rule 4, my lord. I have taken that ground, my lord. Your lordship would be pleased to see page 7, ground number 8. The appellate court violated Rule 4, Order 3 CPC, which provides that an advocate engaged by appellant continues to be his advocate till his death, till completion of proceeding and till he was sentenced by the appellant with the leave of the court or he himself withdrawn from the case. The engaged advocate, if withdrawn from the case, then the learned appellate court would have sent notice to the appellant and the appellant would have got the chance to engage new advocate. Now my humble submission before your lordship. What is this law? Law is for if the advocate did not represent my lord. Your lordship. Order 3, rule 4. Order 3, rule 4, my lord, appointment of leader. Now your lordship will see sub-rule 4. Every such appointment shall be filed in court and shall for the purpose of sub-rule 1 be deemed to be in force until determined with the leave of the court by a writing signed by the client or pleader, as the case may be, and filed in court, and until the client or the pleader dies, until all proceedings in the suit are ended so far as regards the client. Now your lordship would be pleased to see explanation. Explanation has gone further, my lord. Proceedings, here it is said the purpose of this sub-rule, the following shall be deemed to be proceedings in the suit and application for review, etc., etc. So, my lord, I have engaged an advocate. If the advocate did not appear, my lord, that blame cannot come to the appellant. If I am not communicating with the appellant, advocate, it is the duty of the advocate to withdraw from the case with the leave of the honorable court. And after withdrawal, my lord, what will happen, my lord? If I am not represented before the court, my lord, definitely court will send notice that your advocate has withdrawn. How that for this negligence of the advocate, my lord, I will suffer. And your lordship would be pleased to see, it's a case, my lord, where a demand of 2 crore 20 lakhs, 10,890 rupees against me, my lord, by the tax department, by a value-added tax. That is to be looked into. Is a substantial amount involved, my lord. So, my lord, my humble submission before your lordship, for the negligence of the advocate and for this provision of law, my lord, under Rule 4, Order 3 CPC, my lord, I cannot be blamed. Advocate is engaged, advocate did not withdraw. There may be gap of communication, all right, but advocate is not in the problem that he cannot withdraw from the case. If advocate withdrawn, my lord, automatically the court will.
Okay, we will issue notice at this instance.
Yes,
Let
my
the
lord.
other side appear.
Yes, my lord, notice will do, my lord.
Ah.
Notice will do.
Heard Mr. Emetic, learned counsel for the appellant. And Mr. D.R. Gogoi, learned counsel for the respondent number
4, lordship.
Learned government advocate for the respondent number 4, and Mr.
B Gogoi for 1, 2, and 3, my lord.
B. Gogoi for
Standing counsel
respondent
final
number
judgment.
1, 2, and 3.
Yeah, standing of the final.
1, 2, and 3. Standing counsel for the respondent number 1, 2, and 3.
1, 2, 3. I'll serve extra copy. I'll serve extra copy to them.
This appeal under order 43 of 43 CPC 4, setting aside the order dated 5/7/2024 passed in Mizze case number 12 of 2022 by the learned additional district judge Dhuri. It is to be noted here that by the impugn order dated 5/7/2024, the learned additional district judge Dhuri has dismissed the petition filed under Order 41, Rule 19, read with article, read with Section 151 CPC for restoration of title appeal number 14 of 2019, which was dismissed by order dated 27/5/2024 for default of the appellant. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugn order dated 5/7/2024. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their standing counsel. However, the extra requisite copy of the petition, however, be furnished to the learned counsel for the respondents. Call for the scanned copy of the record. Let's list the matter on when? After 2 weeks?
2 weeks, my lord.
After 2 weeks.
A date may be given, my lord. A date may be given. For 2 weeks.
On 2nd September,
Second,
item 14,
not of language.
lordship, I prefer this application on being aggrieved by the order dated 6/7/2024 passed by the learned Civil Judge Senior Division. Lordship, you will find the order at page number 73, where I had filed an application under Order 39, Rule 1 and 2 for ad interim injunction. The relevant part will be at page number 77.
Third, Mr.
G Kaushik. G Kaushik.
C.
G
Kaushik.
Kaushik.
G. Kaushik, Learned Counsel for the appellant.
Lordship, some protection may be given because Lordship, the suit property in question, already a power of attorney has been done. And I have, it is in page number 26. Lordship, it is a property of my father-in-law. My husband eventually passed away. So it is a property of which belonged to my father-in-law. After his death, there were 7 legal heirs of my husband. Subsequently, respondent 1 and 2 were given the responsibility for mutation. And what they did, it is Lordship, which I came to know last year when the suit property, they have demolished the ancestral property and they have done a power of attorney with respondent number 4. And after acquiring the certified copy of the power of attorney, I have come to know that they have done a deed of agreement also with respondent number 4 to build a multi-storied building in the suit property. And I have applied for the copy of the same, but since I'm not a party to the deed of agreement, I have not received it. Lordship, if notices are issued in this case, I fear that some third party rights may be created in this. So some protection may be given, Lordship.
You have filed one IA also.
Yes, Lordship.
Let the other side appear, we will consider your prayer.
Lordship, some protection may at least consider for not to create
Third,
any third
Mr. G.
party.
Kaushik, Learned Counsel for the appellant. In this appeal, under Order 43, Rule 1, read section 151 of the Code of Civil Procedure. The appellants, namely Bhavani Das Bodo, Akshay Bodo, and Ankur Bodo, put to challenge the correctness or otherwise of the order dated 6/7/2024 passed by the learned Civil Judge Senior Division Number 2, Kamrup M, in connection with Mizja case number 612 of 2024, arising out of title suit number 326 of 2024. It is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition filed by the appellants for grant of ad interim ex parte injunction. Where is the memo of appeal and the grounds mentioned therein? Let notice be issued to the respondent, returnable in returnable in 2 weeks. Step be taken by registered post with AD within, and also by usual process within 2 working days from today. Thus day is also permitted. Rest is shall call for the scan copy of the record from the learned trial court. Place the matter after 2 weeks.
Right.
Third, Mr. In IA, you take down. Same. Same. The land is in your possession now?
No.
No.
Land is not in my possession because when they did mutation after the death of my father-in-law, I have not been mutated as the legal heir. They've done leaving behind me, and not only me, there are other defendants also. Defendant number.
Interim period, the petitioner will be considered after receiving the record from the learned trial court. Next step.
Item 15.
I'm for the appeal and appealing for the national and supreme lordship. In this case, lordship, challenging the judgment and award dated 25/1/24 passed by the MSC, learn MSC number 1, Kamrup lordship. Lordship will
What is
find
the
as a
quantum of
Annex A 1,
compensation?
lordship.
5,75,000.
It's a injury case, Lordship. I am not on the quantum, Lordship. And my grounds of appeal are there, Lordship. The Lordship will find case number 7, Lordship. There are 3. So it's a doubtful case, Lordship. Instituted only on a CD entry report, Lordship. And no FIR was lost. And in my
Is there any statutory bar that in connection with a ZD entry,
Yes,
no
Lordship, there's
case
a
can be filed?
taking decisions, and we have a decision of our own High Court, Lordship, passed by the Honorable Justice Surana. That in that case, your appeal was allowed, which was instituted on a ZD entry, Lordship. And now another case.
Okay, we will admit the appeal, we will issue
Yes,
notice,
Lordship, on merit.
but you have to deposit 50% of the amount with the registry of this court within a period of 2 weeks from today.
Let them come. Let the claimant side appear, Lordship.
Pardon?
Let the claimant side appear, respondent number 1 appeal, Lordship. I will take the steps also.
No, we will admit the appeal subject to depositing 50% of the amount. Heard Mr. P.J. Burman, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 25/1/2024. Passed by the learned member MSCT number 1 Kamrup M. Guwahati in MSC case number 1236 of 2016. It is to be noted here that by the impugned judgment and award dated so and so, the learned member MSCT number 1 Kamrup M. Guwahati has directed the appellant to pay a sum of rupees 5,75,690, being the compensation with 6.5% interest per annum from the date of filing the claim petition till payment. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated 25/1/2024. This appeal is admitted for hearing subject to depositing 50% of the awarded amount before the registry of this court within a period of 2 weeks from today. Registry will call for the issue notice to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today.
And Lordship, LCR may be called out.
Registry will call for the record from the learned trial court. And I also issue notice.
Lordship, I admitted also. Yeah, I was admitted.
Not necessary.
I already admitted also.
I admit.
Delay was controlled also.
Oh,
It's
sir, I
admitted for
had
hearing
already
today.
disposed of, okay.
It is the first day for admission hearing.
Interim period not calculated.
Item 16.
Howlett.
Wait. Appeal under section 173, my lord. Impugned the judgment and award dated 21/5/2022. Passed by the MST Kachas. Thereby awarding an amount of rupees 35,21,000. My lord, initially the claimant had filed an FIR, my lord, under section 302 of IPC, my lord, and it was investigated as a murder case. The case ended in filing charge sheet against the truck. Now, the charge sheet clearly indicates.
Case is filed under section?
302, my lord. The FIR was filed by the claimant's mother. And it was later on charge sheeted against the truck driver.
Under section?
My lord, charge sheeted, my lord, under the. It was considered to be an accidental case, my lord, under 374, my lord.
Charged under section 279/427 and 304A.
304.
Acha.
But in the charge sheet, there was a finding that was no involvement of the truck. The truck did not hit the Maruti car. It was the case of the claimant that the deceased had left the home at night, 1:50 in the night, and his mobile was switched on. Early morning at 4:45 a.m., it was alleged that the accident had taken place. The truck tried to overtake the Maruti car, and the Maruti car had fallen in a pond nearby, by which both the driver and the owner of the vehicle had died. That was the case. We had taken a specific plea that it was a case, not a case of accident, but it was a made out case.
It was a?
It was an afterthought and it was a made out case because there was no evidence, no eyewitness were examined in this case.
We will examine the record.
My lordship.
That is, it says, we will admit it.
Lordship, kindly bear with me for a moment. They themselves admitted that their truck was involved. There is an accident case. They took their plea in their written statement.
Well, that all these things.
No, we will hear it.
Lordship, moreover, Lordship, they examined one DW, and DW took the statement of owner, driver, and one eyewitness. Statement is there. All the witnesses stated that the truck hit the car from behind. And charge initially it was suspected that it was a murder case or some miscreants killed the deceased. But police, after investigation, found that the truck was involved. Truck was responsible for the accident. Owner, driver jointly filed written statement. In their written statement, they admitted that, Lordship.
May I submit one more thing, my lord? My lord, we have.
Okay, we will hear you. Today we will
Lordship.
admit it.
Yes.
Let notice go
At
at
least
this
50% may be released.
So, my lord, as regard releasing of 50% is concerned, my lord, we have our objection. My lord, lordship may direct us to make the payment. We will deposit it before the registry. But let them file an application. We will contest. it.
Lordship, if you
Like
Lordship see
similar-
that.
Well, one analogous case which was admitted yesterday, well, the stay was granted, well, and the claimants were asked to file an application for withdrawal.
Lordship, so far as the interim order is concerned, it is the discretion of the court. Lordship, if Lordship see the facts and circumstances of the case and sequence of events, it is a case of accident.
No, we will hear
Initially,
you.
it was the mother of the deceased suspected it due to be a.
Similar, like the previous one. You have to deposit 50% of
Yes,
the
ma'am.
awarded amount before the registry of this court.
My lord, we deposit.
It may be
Okay,
released.
file an application, we will pass order. Necessary
Let them-
order.
Oblige, ma'am. I is there, my lord, separate I is. Separate I for stay is there.
Okay, what is the pair in this IA?
The page 7, madam. Order staying the operation of judgment and award dated 21/5/22, my lord, passed by the MSCT Achar.
Okay, you deposit the 50% amount, thereafter we will consider it.
It may be released.
I will be considered after depositing the 50% of the awarded amount before the registry of this court.
LCR is called for.
Yes, LC.
Lordship directed to deposit 50%.
Pardon?
Lordship directed to deposit 50%.
Yes.
And it may be released. Lordship.
Pardon?
It may be released. Lordship.
You file an application. After depositing the amount, we will pass the order. Let him first deposit the amount.
Within 2 weeks. Lordship.
2 weeks.
Lordship.
Item 17. Oblige.
Your Lordship. Statutory appeal, my lord, without interim prayer, my lord. Appeal filed by the owner of the vehicle, my lord. At this stage, my lord, my lord, appeal will be admitted, notice may be issued, my lord.
What was the quantum of compensation?
Term is, my lord, 9,53,000. But here, my lord, it was a case under 166 and rational negligent driving was not proved, my lord. I have annexed the judgment of the criminal proceeding, my lord. At page 27, my lord, it has been clearly held, my lord.
Criminal proceeding
Yes, my lord.
against the driver,
Owner and driver,
owner and driver.
My
There it has been held that it is not proved.
my lord.
But
Only
this
I
is not
witnessed, my
a
lord.
criminal proceeding. This is a civil proceeding.
But my lord,
Whether the standard of proof is not same with the criminal proceeding.
yes, my lord, but in the criminal proceeding, it was held that, my lord, it was not at all negligent, my lord.
Maybe,
As per the evidence of the eye witness, and that has been ignored by the tribunal, my lord.
maybe
Tribunal
when
has,
there
my
is
lord,
any preponderance of probability, then the member of the MSCT can
but my lord,
compensate.
your lordship,
Okay, we will hear you.
my lord,
Let the record come.
my lord,
You have to deposit 50% of the amount.
my lord, I am not seeking stay at this.
Maybe,
My lord.
even then, we will admit it on that condition, that you have to deposit 50% of the amount within
My lord,
a period of 2 weeks from
let the
today.
claimants may execute, my lord, but because we are not seeking stay at this stage. my lord.
Maybe
Let them
you may not
execute,
seek
my-
stay.
My lord.
You have to deposit the amount.
But my lord, my humble submission is that, my lord, the court tribunal, my lord, lordship, only page 52, my lord. The tribunal has clearly held that, my lord, since it's an application under 166, my lord, the claimant must show that the driver was negligent, my lord.
Thereafter,
But thereafter, it has held that, my lord, as per the evidence of the hearsay evidence, my lord.
okay, we will consider your submission after receiving the record from the trial court. Let the record come.
My-
Same
Item number
order.
eight-
Same order.
item number 18.
Much okay.
Also, this is an appeal against an award passed by the member in Mr. Nogao on the ground that, let's say, the accident occurred on 28/1/2022. FIR has been filed on 18/3/2022, showing involvement of a motorcycle AS 26B6550. And that motorcycle belonged to the brother of the claimant number 1. He is a resident of, let's say, the other place, and his vehicle has been implanted by the claimant to get illegal gains. In fact, we have got the inquiry, and after inquiry, we came to know that this is himself driving a motorcycle with an accident. And subsequently, after 2 months of the accident, FIR has been filed, implanting another vehicle that he hit the deceased. This is a fraud on the part of the claimant to get illegal gain by implanting a vehicle which belongs to the brother of the claimant number 1. There are other grounds, but this is the main ground. It's the implant of another vehicle. After 2 months of the accident, they have implanted the vehicle. Deceased himself was driving a motorcycle. He drove the vehicle and hit a divider and made the accident. After 2 months, FIR has been filed stating another vehicle. That also belongs to the brother of the claimant number 1.
Okay, let the record come. We will admit the appeal. But deposit, you have to deposit 50% of the amount.
We'll deposit the reason not to release at this stage.
Oh, we'll see. Let the other side appear.
Lordship.
Oh, same order. After 4 weeks?
Lordship, state by registered post.
Yes. And usual process also.
For bail hearing, item 19.
Lordship, in this case, I'd like to file one additional affidavit to bring on record some relevant documents in favor of me.
Mr. A.Z. Ahmed, learned counsel for the accused, submits that he will file an additional affidavit in this application and press for granting him
21.
1 week.
Yes.
1 week time.
Yes.
Okay, they are allowed.
Item 20.
In this, the CD was called for, lordship. We have not received the CD, lordship. Sorry, maybe given lordship.
CD not received. You are on interim.
My lord.
On the pair being made by Mr. P.S. Locker learned additional PP to grant him further time to produce the case diary. The case is then adjourned to be listed on when?
On 21st.
However, it is made clear that no further opportunity will be afforded to Mr. Locker to produce the case date. In the event of his failing on the date fixed to produce the case date before this court, the court will proceed to hear and dispose of the application on the basis of materials available on the record. Till then, interim order passed earlier, dated 27/6/2024, shall continue.
Item 50.
Also, here in this, I have appeared in our office, lordship, but we have not received the notices from the petitioner side, lordship. And as now they have stated, lordship, that they have served a copy of the petition and that about that particular dealing of his assistant have not received that petition, lordship. Actually, nowadays, for taking steps, they used to prepare that notice so that we can send it directly, lordship. So they have to send give us a serve us a notice, lordship, so that we can send it immediately, lordship.
So he will submit a copy of the notice to you
Lordship, in a notice
today.
Yeah,
When?
If he submit it today, lordship, we can send it today itself, lordship.
Today, lordship. Lordship, actually, copy was served, lordship.
Copy served in the office.
No, you have to serve through the PP,
Lordship.
office of the PP.
Lordship. Earlier also like same copy of served to PP, lordship. Then PP collect the report, lordship.
And there is no such
In this case, lordship.
availability of staff in our office that lordship preparing of notice and everything is it is not possible for the office staff. Limited staff is there, lordship, 2 or 3 persons.
The learned counsel for the no, Mr. P.S. Locker learned additional PP submits that he has not received any report in respect of service of notice. The learned counsel for the applicant, counsel for the accused submits that he will take fresh step upon respondent number 2. There is accordingly allowed. Rest shall list the matter. 1
27.
27. Sort that. Oh.
22nd. 22nd.
22nd. 22nd.
Second lordship,
Sort that. 2 sort.
sort of.
Okay, then 27.
27.
The learned counsel for the applicant shall take step during the course of the day.
Obviously.
So I just for hearing under order 41, move to CPC 21, item 21.
Thank you, Your Lordship. On the previous occasion, I sought some time for rephrasing the substantial question of law. Just to briefly, I have done that, just to briefly narrate the facts once again for the facts, Your Lordship. This was a suit for specific performance of contract, Your Lordship. Possession was handed over, and thereafter, Your Lordship, the amount was also paid, Your Lordship. However, the courts below held that it was not a proper contract, hence it could not be, there could not be any decree for specific performance of contract. However, page 46, at page 61, Your Lordship, in the appellate court judgment, para 48, page 61. The fact of payment of money was proved at para 48. So the consideration was proved.
However, the court held that since there was no prayer for refund of the money cannot be refunded at this stage. So consideration payment was proved, Your Lordship, but the court was not inclined to pass a decree for specific performance because according to the court, the
Okay,
agreement, Your
heard
Lordship,
Mr. Vijay Mukherjee, learned counsel for the appellant. This second appeal is directed. No, this appeal under section 100 of the Code of Civil Procedure is directed against the judgment and order dated 31/3/2024 in TA number 07 of 2023, passed by the learned Civil Judge Senior Division Kukurajar. Is to be noted here that by impugned judgment and order dated so and so, the learned Civil Judge Senior Division Kukurajar had dismissed the appeal and uphold the judgment and decree dated 3/6/2023, passed by the learned Civil Judge Junior Division Kukurajar entitled suit number 9 of 2021. That is the memo of appeal. This appeal is admitted for hearing on following substantial question of law. Number one, whether the learned courts below justified in denying the decree of specific. No, trial court has allowed the
court has not allowed.
not allowed. Whether the learned courts below are justified in denying the decree of specific performance of contract even when the execution of the document and payment of consideration are proved and all the ingredients of section 10 of the Indian Contract Act are satisfied with. Number two, whether the finding so recorded by the learned courts below are sustainable in view of the provision of section 53A of the Transfer of Property Act 1882. Number three, whether the first appellate court erred in law in denying the relief of refund of the advance consideration due to lack of pleading, even when the court itself held that the payment of the amount is proved. So I go to courts below Neleke, learned first appellate court, and also the learned trial court. দুই নম্বৰটো একে লিখিব কোর্ট বিলো নেলিখিব Recessal call for the record from the learned court of first appellate learned first appellate court as well as from the Court of Civil Judge Junior Division Kukurajar. List of purpose.
Tips.
Notice safe returnable and for which is to be taken by registered post with AD and also by usual process within a week. Next.
Item 22.
The second appeal again is so concurrent findings by the trial court and appeal filed with the lordship. First appeal was dismissed, lordship. Substantial question of page 4.
So what are the substantial question of law?
Page 4, Lordship, I have been, Lordship. 5 questions.
Is this space for is a part of the memo of appeal?
Part of the Lordship, page 4, Lordship.
Maybe, but have you mentioned it in a memo of appeal?
Yes, Lordship.
Where?
Substantial question of page 4, Lordship.
No, page 4 is a loose sheet, not a part of the memo.
Memo of appeal, Lordship, 1 to 5, Lordship. Lordship, kindly see index, Lordship.
Pardon?
Lordship, kindly see index, Lordship, memo of appeal.
But you have to mention in the memo of appeal specifically. You see subsection 3 to section 100.
This continuation of appeal, memo of appeal, Lordship. Continuation, Lordship. Lordship, may kindly have page 3.
You read section subsection 3 to section 100.
May I read, Lordship? In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal, Lordship. Lordship,
Have you mentioned it in the memo of appeal?
Lordship, page 3, Lordship, bottom part, Lordship. This appeal is prepared, prepare this memorandum of appeal among the following grounds, Lordship. Page 3, top, bottom, Lordship.
Page 3?
Bottom, Lordship. This continuation.
Acha, okay.
Continuation, Lordship.
Heard, Mr.
MK Hussain, Lordship.
This regular second appeal is directed against the judgment and order dated uh, 31/5/2024 passed entitled appeal number 11 of 2023 passed by the learned civil judge senior division Lakhimpur, North Lakhimpur. Is to be noted here that by an impugned judgment and order dated so the learned civil judge senior division Lakhimpur dismissed the title appeal, thereby affirming and upholding the judgment and order dated 8/9/2023 and the decree dated 16/3/2023 passed entitled suit number 4 of 2015 passed by the learned Munsim number 2 Lakhimpur, North Lakhimpur. Where is the memo of appeal and the grounds mentioned therein and the impugned judgment and order dated so and so. In title appeal number 11 of 2023 and also in title suit number 4 of 2015 dated 16/9/2023. This second appeal is admitted on the following question of law, admitted for hearing on the following question of substantial question of law. Number one, whether the respondents are entitled to any relief from the trial court as well as lower appellate court without having title and possession over the suit land. Number two, whether learned lower appellate court is justified in shifting the onus of proof upon the appellants, where the respondents have miserably failed to prove their pleaded case during trial. Whether the appellants are legally entitled to be evicted from the suit land since the appellants have been enjoying exclusive possession of the suit land by constructing dwelling house and by planting trees. Whether the appellants are liable to be evicted from their land on the basis of uncorroborated testimony of the respondents. From any independent witnesses and in absence of any documentary evidence. Next. Whether the appellate court whether the finding of the learned trial court as well as appellate court are sustainable in law in view of the suit barred by limitation. Issue notice to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Registry shall call for the record from the learned lower appellate court and also from the learned court of civil judge. Munship
Two.
Munship 2.
Look into it. I, their lordship.
Let the other side appear. Notice will go at this instance. There is concurrent finding.
The respondent husband, my lord, in one hand, my lord, filed a case for resumed conjugal life. And on the other hand, my lord, filed a suit for decree for dissolution of marriage.
So what is your pair in this petition? Because only summon was issued to you.
My lord, my lord. It is, my lord, to set aside the order dated 7/5/2024, my lord.
Why?
My lord, No contradictory relief has been sought by the husband, my lord, in two petitions, my lord. Page number 19, my lord, file execution case for resume conjugal life. And page number 22, my lord, he sought degree for dissolution of marriage.
So this title suit number 1 of 2024.
My lord,
Where is the order?
in this case, my lord, Shaman was issued, my lord, to me, my lord.
Whether both the cases are pending?
Both the cases are pending.
So this ex parte proceeding has already been,
My lord.
no, the title suit number 2 of 23. Ex parte order has been passed.
My lord, this has already been challenged in our high court, my lord.
And thereafter, he had instituted this title suit number 33 of 2024.
That, my lord, execution case has been filed, my lord.
Hmm?
That page number 19, my lord, execution case has been filed.
Page number 19.
And 21 summon was issued to me. Page number 21, summon was issued to me in that case.
So against this, you have filed a petition before this court.
My lord. Thereafter, my lord, page number 22, he filed another suit for this.
Let notice go at this justice. Interim pair, if any, will be considered on appearance of the other party. Pardon me, sir.
FLS comment.
Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read it. Section 115 and 151 of the Civil Procedure Code. The petitioner has put to challenge the correctness or otherwise of the order dated 7/5/2024 passed by the learned district judge Hailakandi in title suit divorce bearing number 33 of 2024. It is to be noted here that by impugn order dated so and so, the learned district judge Hailakandi has issued summon to the petitioner for appearing in the said case and to file written statement. The learned counsel for the petitioner submits that the respondent had earlier instituted one suit for restitution of conjugal right, and the said suit was decreed ex parte, and thereafter the respondent has instituted one title suit within bracket R execution case number 1 of 2024 before the Court of Learned District Judge Hailakandi. And against the ex parte decree, passed in title suit number 2 of 2023, the petitioner that preferred an appeal
It's not numbered, my lord. There is a condonation petition, my lord.
had already preferred an appeal before this court. And the same is yet to be numbered as there is a petition for condonation of delay. The learned counsel for the petitioner further submits that thereafter the petitioner has instituted another suit being title suit written to get divorce number 33 of 2024 before the Court of Learned District Judge Hailakandi. And according to him, the pair in both the suits are contradictory to each and contradictory. The submission of the learned counsel for the petitioner needs further consideration, and this is this notice to be issued to the respondent, returnable in 4 weeks, is to be taken by registered post with AD and also by usual process within a week from today. Call for the scanned copy of the record from the learned trial court. List the matter after 4 weeks.
There is a pair for interim, my lord. Interim pair will be considered.
There is no pair in the petition. Where?
Sorry.
Where you have mentioned about your interim pair? Oh, interim is okay. Interim pair will be considered on next date after receiving the record from the learned trial court.
Obliged.
Timing item number 11.
This order is-
My lord, it's an application for modification of the order
Mm.
passed by Honorable Justice Malosri Nandi, whether your lordship
Mm.
like to take it. my lord.
But there is an order that 22nd March 2024, wherein it is directed that the matter may be listed before appropriate court.
So I feel so. It may be listed to the appropriate.
Yes. In view of order dated 22/3/2024, SSL list the matter before appropriate bench.
Obliged.
Item number 25.
23.
Item 25.
May I please your lordship? My lord, I am appearing for respondent number 2. And last 2 occasions also showed the appellant not appeared. I am respondent lordships.
So what is your submission?
Matter may be closed lordships since interested, not interested appellant side.
None appears for the appellant on call. However, Mr.
F.U. Borbuya.
F.U. Borbuya, learned counsel for the respondent present. Mr. Borbuya submits that on 2 previous occasions, also the appellant remained absent without any step. And in view of the conduct of the appellant, Mr. Borbuya submits that the matter may be closed. There appears to be substance in the submission of Mr. Borbuya, learned counsel for the respondents. It appears that on 5/8/2024 and also on 27/6/2024, the appellant remain absent. The appellant remain unrepresented In view of above, this RSA stands dismissed for non-prosecution. Obliged.
Item 26.
Lordship, I am appearing for respondent number 3, India Insurance.
None appears for the applicant on call. However, Mr. S. Dotto, learned counsel for the respondent. Number 1.
Respondent 3, Your Lordship.
Respondent number 3 present. The respondent number 1 also remain unrepresented today. It appears that on 27/5/2024 and 4/3/2024, the appellant, no, the applicant remain absent without, the applicant remain unrepresented. Accordingly, it is provided that registry shall list the matter after 1 week. In the event of subsequent non-appearance, appropriate order shall follow.
Much obliged.
27.
My lord, my item is 24, but it is.
Yes, yes, because we are
My lord, it is simple matter, if permits, I can.
Yes, the next item, please.
My lord, what happened, my lord, in the memorandum of appeal, the substantial question of law is not incorporated. It is given as a separate sheet, my lord. So I may be allowed to amend the amendment. Memorandum. 24. 24. I may be simply allowed, my lord.
1 week.
It is not incorporated in the
Memo of appeal.
memo.
Okay.
Substantial question. I will.
On the pair being made by Mr. D.C.C. Fukon, learned counsel for the appellant. Registry shall list the matter after 1 week,
My lord.
so as to enable him to amend the,
I may be allowed to amend, my lord.
yes, to file amended cost title.
Yes.
No, to file amended memo of appeal.
23.
Incorporating the substantial question of law.
23.
Also 27, in item number 27, I was there.
Yes, sir, we will call the item, just wait for one. Item 23.
My lord, this is the second appeal, my lord. The substantial question of law at page 7, my lord. My lord, earlier, this is the second round of second appeal, my lord. Earlier round of second appeal filed by me, that was allowed by remanding the case to the learned lower appellate court to decide whether the plaintiff has right title interest, and number 2, whether the plaintiff is entitled for recovery of khas possession. But the learned lower appellate court, what did, my lord, basing on the commissioner's report, without looking into other evidence that my title deed, my apart from that, they are also admitted that they are claiming adverse possession against me. Even thereafter, on the basis of the commissioner's report, held that I have no right title interest over the subproperty. And that too contradict to the commissioner's report. May I show that page, my lord? Page 80, my lord, can 80. Whether the learned trial court has wrongly decided issue number 4 and 5 and has not properly appreciated the fact and evidence on record in dismissing the suit of the appellant plaintiff. Now, decision discussion, it may escape straightway go to, my lord, page 84. 84, kindly see. Now, as regard the issue number 4 is concerned, it is to whether the appellate plaintiff has got right title interest over Schedule C land. It may also skip, my lord, this page from 85, kindly see.
the learned trial court has decided instant issuing negative against the appellant. Now, the Honorable High Court,
Let us see the substantial question of law.
page 7. One additional evidence was application for order 41, rule 27 has been filed before the appellate court also. That also decided separately. I prayed that this additional evidence is to be considered along with the main appeal. But before passing of the judgment in main appeal, that order was passed, that additional evidence is also not maintained. Basically 1 to 4.
So, you have suggested as many as 8 substantial question of
No,
law.
1 to 4. 1 to 4 will be.
1 to 4 are material.
Yeah. Earlier round of second appeal, the regarding adverse possession has been set aside and remanded to the trial court that no, this case is not a case of adverse possession. It is not barred by limitation. It is to be decided whether the plaintiff, I am the plaintiff appellant. Plaintiff have right title interest over Schedule C land or not. But the learned again this the lower appellate court when after remand on the basis of Amin Commissioner's report held that I have no right. Without going through the Exhibit 1, Exhibit 2, the Khatian which I have produced and the Khatian which was issued in favor of the plaintiff basing on the cell deed, my lord. 2 cell deeds. That 2 cell deed also I have brought by way of additional evidence. That has also been rejected. That order also I have annexed in this memorandum appeal.
Okay. I heard Mr. Hussain. Okay, Ghosh, SK Ghosh, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure. The appellant has put to challenge the correctness or otherwise of the judgment and decree dated 6/5/2024 passed by the learned civil judge senior division Kokrajhar in title appeal number 4 of 2006. It is to be noted here that by impugned judgment and order dated 6/5/2024, the learned civil judge senior division Kokrajhar has dismissed the appeal and upheld the judgment and decree dated 38/3/2006 passed by the learned civil judge junior division Kokrajhar in title suit number 27 of 1991. Dismissing the suit of the plaintiff. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and order, judgment and decree dated so and so. Passed by the learned civil judge, senior division Kokrajhar in title appeal number 4 of 2006. And also the judgment and decree dated 30/8/2006, passed by the learned civil judge, junior division Kokrajhar in title suit number 27 of 1991. This appeal is admitted on the following substantial question of law. Number 1. whether learned lower appellate court erred in law in not declaring the title of the plaintiff, though the plaintiffs have been able to prove the Khatian within bracket Exhibit 1 and 2 issued in favor of the predecessor in interest of the plaintiffs, as well as the title deed which was brought by the appellant stroke plaintiffs through additional evidence. But the learned lower appellate court did not consider the additional evidence in Mizje case number 15 of 2024. Number 2, whether learned lower appellate court erred in law in not declaring the right title and interest of the plaintiff over Schedule C land, although the defendant stroke respondents having pleaded and deposed on oath that they have never encroached the Schedule C land. Number 3, whether the finding of the learned courts below that the plaintiffs have no right, title, and interest over Schedule C land, basing on the report of the Amin Commission, and that the defendant number 1 has acquired title thereto by adverse position or perverse. Number 4, whether learned lower appellate court erred in law in holding that the defendant number 1 has acquired ownership, although no counterclaim was filed by defendant number 1. Let notice be issued to the respondents, returnable in 4 weeks, is to be taken by registered post and also by usual process within a week from today. Call for the record from the learned courts below. Or list the matter after 4 weeks.
27.
Lordship, in this case, I am for the respondent, Lordship. So last date also, they were not present applicants.
You are for the respondent.
Yes, Lord.
Respondents are the claimant.
No, Lordship, the claimant is a petitioner here. The main appeal is already disposed, Lordship. And they have
This
filed-
IA is for what purpose?
They want more interest, Lordship, but we have, our contention is we have already paid entire amount, Lordship.
You have paid the interest.
Yes, the awarded amount plus interest, everything is paid, Lordship. But they are demanding more interest, Lordship.
You are for the insurance company.
Yes, Lordship.
None appears for the applicant on call. However, Mr.
KJ Saikia, Lordship.
Learned counsel for the respondent present. It appears that on 26/6/2024 also, the applicant remain absent. The applicant remain unrepresented. This is the matter after 1 week. In the event of subsequent non-appearance of the applicant, appropriate order shall follow.
28. Please, Your Lord. Petition was filed, my lord. Against the order, my lord, on page number 38, my lord. Miss, in that case, my lord, this, in that case was filed, my lord, against the order of dismissal. This is, my lord, page 17, my lord.
This is for default, my lord. The title should. My lord. What happened, my lord? Petitioner
No, whether you have taken any step upon respondent number 2?
Yes, my lord. Yeah.
Oh,
My
you
lord,
are for
I have
respondent number
responded
2.
for one.
1.
Yes, my lord. As per office note dated 9/8/2024, service upon respondent number 2 has not been completed.
Oh, sorry, sir. Sorry, 29. I'm sorry, ma'am. Next time.
Acha. You are,
May I please, I'm for 28, my lord. My lord, I am sorry, my lord, we could not take fresh step upon respondent number 2 and 3, my lord. My lord, kindly allow us 2-3 days, my lord, for last time. We will take fresh step upon
heard
respondent.
me, sir. You can learn it counsel for the appellant and madam
J. Sharma.
J.
for
Sharma,
respondent
learned
number
counsel for the respondent number 1. Mr. Khan submits that due to some inconvenience, he could not take step upon respondent number 2 and 3, and he pressed for granting him 1 week time to take step upon respondent number 2 and 3. Here is accordingly allowed to be taken within a week from today upon respondent number 2 and 3 by registered post and also by with AD and also by usual process. This is the matter after 4 weeks.
Obliged, my lord.
Deeply obliged.
29. My case, my lord. Petitioner failing the order of the Lord Munshi, my lord. The order on page 38, my lord. And this was filed, my lord, against the order of dismissal. on
So
default,
this
my lord.
respondent number 4, neither AD card nor unserved notice received.
I have already.
Pardon?
Notice has been taken, my lord. on
Taken, but
my
it
part.
has not been received. Hmm? When you have taken a step?
These are, my lord, press statement.
File on behalf of 1, 2, 3. This is in respect of 4. Third, Mr. A.J. Atia, learned counsel for the petitioner. None appears for the respondent number 1, 2, 3. Though counsel name reflected in the constitution. Though the name of some advocates reflected in the call list. Office note dated 12/8/2024 indicates that neither AD card nor unserved notice received from the received in respect of service of notice. No, in respect of respondent number 4. So list the matter after 1 week, 2 weeks, awaiting service report upon respondent number 4.
All respondents from the same family, my lord.
Pardon?
All the respondents from the same family.
Maybe, but even then you have to
Yes.
obtain the report.
Item 30. All right.
Yeah, my lord, as per office note, my lord, 9/8/2024, my lord. Service upon the respondents of 1 to 4 has been rejected, refused, my lord. The office note. That will be allowed to take fresh steps, my lord.
Heard, Mr.
Please shake, my lord.
T. Sheikh, learned counsel for the petitioner, no, for the appellant.
Appellants, ma'am.
Office note dated 9/8/2024 indicates that notice issued to the respondent number 1, 2, 3, and 4 returned with a report, refuse RTS. In view of above notice deemed to have been served upon respondent number 1, 2, 3, and 4. But the chooses not to contest the appeal. List the matter. After 1 week for hearing, no, in usual course. Recessal is the matter for hearing in usual course.
31.
Respect, my lord. My lord, pass over for the day, my lord.
On the appeal being made by Mr.
A. Dutta, my lord.
Learned counsel for the petitioner, the case stands adjourned for the day.
And my lord, date on list on my lord, day after tomorrow, my lord, Friday, my lord.
Friday not possible. Next week.
Okay.
32.
May I please, your lordship? Lordship, with regard to respondent number 1, I have taken justice service and the affidavit to that effect has been filed. And he is appearing on behalf of respondent number 2 and
2 and 3.
2 and
3, lordship.
2 and 3.
In page 79 of that affidavit, your lordship will find the justice was taken on 7 to 24, your lordship. There are 3. And the affidavit was filed on 4 of March 24.
Heard Mr. A. Viswas, learned counsel for the appellant. And Mr.
P.K. Basu.
K. Basu.
P.K.
learned
Basu.
Counsel for the respondent number 2 and 3. Mr. Viswas submits that service upon respondent number 1 is effected by Dastemut. And therefore he has submitted an additional affidavit to that effect.
An annexure I is the letter on which he has endorsed. Your lordship. Page 81 is the
And it appears that respondent number 1 has received a notice. But he remained unrepresented today. In view of above, it is provided that recessal is the matter. It is admitted already.
It is already admitted.
So
And the LCR has
for
already-
hearing then,
LCR has been received.
LCR received.
Because it is a probate case, it went against me, your lordship. I was the beneficiary to the will, which was rejected by the trial court.
No, this LCR is received or not?
Yes, it is received.
Received. So then hearing,
Yes, sir.
recessal is the matter for hearing in usual course.
It would be, a date may be fixed because the property will be, my elder brother is the respondent number 1. He is trying to, so a date may be kindly fixed. Your lordship.
Okay, after about 1 month, definitely they will list it.
Yes, your lordship. Obliged.
Item 33.
May I please, your lordship? As per the office note dated 9/8/24, service has been completed for respondent number 2 and 3, and the respondent number 1 has been expired, your lordship. Your lordship, please direct the respondent number 2 and 3 to furnish the legal heirs names of the respondent number 1.
Respondent number 1 expired.
Yes, your lordship.
So a direction may be issued to the respondent number 2 and 3 to
To furnish the names of the legal heirs of respondent number 1.
We'll try to provide them with the names of the legal heirs, your lordship.
Your lordship, one more. My senior's name has not been shown in the cause list, your lordship.
who is your senior?
A. Iqbal. We requested on the last date also, your lordship.
Item 33.
Heard Miss
S. Siddika.
S.
Siddika.
Learned counsel for the learned counsel appearing on behalf of Mr.
Iqbal.
A. Iqbal, learned counsel for the appellant. And Mr.
A Das.
A. Das, learned counsel for the respondent number 2 and 3. 2 and 3. The learned counsel for the appellant submits that appellant number 1 suffered demise. And as such, see, Prideful is showing direction to the respondent number 2 and 3 to furnish the details of legal heirs of respondent number 1. Here is accordingly allowed. The learned counsel for the respondent number 2 and 3 submits that he will try his level best to furnish the details of legal heirs of respondent number 1 within 1 week or 2 weeks.
1 week cannot.
1 week. One. Rest is the matter after 1 week.
34.
May I please, your lord? I am extremely sorry to say that I could not take steps, my lord. I undertake to
Acha.
stay within a week.
Your good name?
S. Chauhan.
S.
Chauhan.
Sohan. Mr. S. Sohan, learned counsel for the appellant submits that due to inadvertence, he could not take a step upon the respondent and prayed for granting him some time to take a step upon respondent number or upon the respondents. Here is accordingly allowed. Recessal is the matter after 4 weeks. Step upon respondents be taken by registered post with AD and also by usual process within a week from today. This after 4 weeks.
Highly obey.
Huh? এই জজমেন্ট বিলাক পিছত নিদিয়ে কিয় প্ৰথমতে যে দি দিয়ে কিন্তু প্ৰথমতে গাছি দিয়াৰ ফলত কি হয় আপুনি হেৰি কৰিব বিচাৰি কৰিবলৈ কোন কমালে মানে সেইটো ক'ত আছে এতিয়া এইখিনি ইয়াত কিয় গাঁঠি দিব লাগে প্ৰথমতে কিয় গাঁঠি দিয়ে ফলত কি হয় এইটো বিচাৰি থাকোঁতে বহুত সময় যায় এতিয়া এপ্ৰিল মেমতো বা পিটিশ্যনটো বিচাৰি থাকিলে বহুত দেৰি হয় ফলত এইটো প্ৰথম মাতি দিয়া হ'ব 54 আচ্ছা ওকে
35.
May I, my lord? Time may be granted lordship taken steps.
Your good name?
H. Islam on behalf of B. Sinha.
Mr. H. Islam, learned counsel, appearing on behalf of Mr. B. Sharma, learned counsel for the appellant submits that he may be granted some time to take a step upon the respondents. Here is accordingly allowed. Recessal is the matter after 4 weeks. Step upon the respondent be taken by registered post with AD and also by usual process within 2 working days from today.
36.
May I please, your lordships? My lord, there is a stay petition 1713. I am not pressing the same, my lord. That may be closed, my lord. That's because my suit was dismissed. Therefore, nothing to stay, my lord.
IA number?
1713, my lord.
Your good name?
J.H. Soikia.
Mr. J. A. Soikia, learned counsel for the applicant submits that he will not pursue this interlocutory application and accordingly submits that this IA may be closed. Where is accordingly allowed, this IA is thus closed.
But regarding appeal, my lord, LCR has been received, my lord. That may be posted for hearing, my lord. In the meantime, my lord, I have to verify.
So
whether
respondents are represented?
Appearing on behalf of respondent.
Oh, all the respondents?
No, 5 to 9, madam.
Pardon?
5 to 9.
5 to 9.
1, 2, and 4, my lord, I have to verify, my lord. One Mr. Noor Syed Ali was appeared, my lord.
Oh,
One Mr. Noor Syed Ali is appeared, my lord, but I peruse the case record, my lord. His Boklaknama is not here, but he received and acknowledged the copies of the appeal, my lord. I furnished, my lord, to him, my lord. But his
so
Boklaknama is
you
not
want
available.
to, what to do? You want to take fresh step or you will inform him?
My lord, sometimes may kindly be given to verify whether it is duly
Acha,
served or-
okay. Heard Mr. So learned counsel for the appellant and also heard Mr. P.K. Goswami, learned counsel for the respondent number 5 to 9. Respondent number 10 to 12 remain 10 to 13 remain unrepresented today.
My lord,
And
10
in
has been
respect of
struck,
respondent number 1 to 4,
my lord.
the learned counsel for the appellant submits that he will verify the record whether any counsel had entered appearance on their behalf. Where is accordingly allowed, recessal is the matter after 1 week,
2 weeks, my lord.
2 weeks.
37.
Please, your lordship. My lord, sorry to say, your lordship, I forgot to take step, your lordship. In I 5 to 9, your lordship. I may be allowed.
Mr.
Here.
A. Roman, learned counsel for the applicant submits that due to inadvertence, he could not take a step upon respondent. You are for
I am for respondent number 1 to 11, except respondent 3 and 7.
3 and 7
Except respondent 3.
upon respondent number 3 and 7. You
Accept
could not
this.
take a step.
My lord, in this IA, my lord, I filed for substitution of legal years of respondent number 3 and 7. 3 and 7 died, my lord. And I have to take a step on legal years of respondent number 3 and
Okay,
7.
okay. Rest of the respondents are represented by Hart Mr. So learned counsel for the, and also Hart Mr. So learned counsel for the respondent number so. The learned counsel for the applicant submits that due to inadvertence he could not take step. So substitution of legal heirs of respondent number 3 and 7 and press for granting him some time. Here is accordingly allowed. Recessal is the matter after 4 weeks.
Right.
So as to enable the learned counsel for the applicant to take a step upon the legal heirs for implement of legal heirs of respondent number 3 and 7.
39.
I'm waiting for the respondent number 5, my lord. I don't know.
This IA is for what?
There is delay of.
There is a delay of 44 days, my lord.
Delay of
address which was given in Tinsukia, my lord. Although there is nothing in the office note, but we have approached and we have seen that, my lord. That notice is also returned back, my lord. The address is not located, my lord. There are two addresses, my lord. We have approached the sections, my lord, and in computer we have seen that the status of the notice sent to the address of Tinsukia, my lord. But I have searched, my lord, in office note, there is nothing, my lord, in this regarding the steps taken in her address at Tinsukia, my lord. In the petition, my lord, Hatigam address was shown in her petition before the learned court below, my lord. And that address we have taken up is the was returned back, my lord. And during this period, she was living in Tinsukia.
So, as per office note dated 29/7/2024, the notice issued to the sole respondent received answer with postal remark as addressee cannot be located at this address.
Yes, my lord.
Hence RTS.
At that address was given in her petitions before the learned court below. In that address we have sent, it was returned back. And during the pendency of the case, my lord, before the learned court below, she was living in Tinsukia. We have collected that address also. We have written in the cost title, and that address also we have sent the notice, my lord. Although there is nothing, but we have approached before the sections, my lord. Then in sections we have seen in the computer, we have seen that the notice which was sent to Tinsukia, that was also returned back, my lord.
Now, what is your prayer?
Now, prayer, my lord, if your lordship permit, my lord, we will take steps through the advocates of the respondent, which is conducting her case before the learned court.
Okay, Dastimut then, Dastimut.
Through the advocate of the respondent. Because we also don't know where she is now living, my lord. Because both addresses.
Heard Mr. M.A.I. Hussain, learned counsel for the petitioner. Office note dated 29/7/2024 indicates that notice issued to the sole respondent returned answer with a report. Inverted comma, addressee cannot be located at this address, hence RTS. The learned counsel for the petitioner submits that he may be permitted to effect service of notice upon the respondent by Dastimut pair is allowed. Step be taken within one working within a week from today. And after effecting service upon respondent number from the respondent, the council shall file an affidavit before this court.
In this regard, very small player, my lord, we also cannot now know the actual resident of the respondent. If your lordship permit, we will take dusty service through her advocates, which is conducting.
No, you do it as you like. You filed affidavit later on.
Will be taken up, my lord, if it is written. In
That cannot be reflected in the order.
43.
Hey, current respondent lordship. Prisoner site is, appellant site is not available.
None. Yes, Mr. Dotto.
43.
Are you not applicant in this IA?
Which item?
43.
43. Your lordship, I have in 44, 48, your lordship.
But here your name is there as
Your lordship.
Dotto.
Your lordship, I will have to verify once whether.
Okay. None appears for the applicant on call. However, Mr.
M. Alamgir.
M. Alam, learned N. Alamgir, A. Alamgir.
M. Alamgir.
M. Alamgir, learned counsel for the respondent present. List the matter after 1 week.
44,
May I please, my lord? My lord, as per the last office note, my lord, unserved notice on respondent number 1. With regard to respondent number 1, my lord, unserved notice is returned back. And my lord, 2 and 3, my lord, AD card received with eligible signature, my lord. And our respondent number 4, my lord.
You are for
Respondent number 4, lordship.
4.
But I may be allowed to take lesser steps on respondent number 1.
Heard Mr. A.K. Gupta, learned counsel for the applicant. And also heard Ms. M. Nirala,
Yes.
learned counsel for the respondent number 3.
4, lordship.
4, respondent number 4. Office note dated 27/6/2024 indicates that AD card in respect of respondent number 2, 3, and 4 has been received. The AD card, the signature of the recipient in the AD card. No, signature of the recipient of notice issued to the respondent number 2 in the AD card is not legible. The office note also indicates that notice issued to the respondent number 3 returned AD card in respect of the notice issued to the respondent number 3 returned with the signature of the respondent number 3. But no one entered appearance on behalf of respondent number 3 in spite of service of notice. Accordingly, it is provided that the learned counsel for the applicant shall take fresh receipt upon respondent number 1 and 2 by registered post with ADA and also by usual process within a week from today. List the matter after 4 weeks.
45,
You are for respondent.
Yes, lordship.
None appears for the applicant on call. However, Miss
S. Soikia on behalf of RJ Das for respondent number 1.
Miss so and so, learned counsel for Mr.
RJ Das on behalf of.
Arzedas present. List the matter after 1 week. In the event of subsequent non-appearance, non-representation of the applicant, appropriate order shall follow.
46,
Your lordship, my senior is on Lex in court 1. One hearing matter is going on. So lordship, matter may be fixed any other day, lordship.
Lordship, today was fixed by the opposite counsel itself. Lordship may grant a passover after 2-3 matters may pick up this matter. It can be disposed of by today itself, Lordship. The law is very much settled in regard to condonation of delay in railway matters.
Lordship, kindly matter will fix after week, Lordship. Won't be available today.
Lordship, today's date was fixed. They have only fixed a date today, Lordship, for today.
Maybe, but the council is being engaged in another court.
Lordship may grant passover after 2-3 matters.
Okay, we'll see after some time.
Much obliged, Lordship.
48. Sorry, 47.
Sir. This LA appeal has been filed for a condemnation of delay of 400 3 days lapse. Analogous appeal, a series of LA appeals has been filed arising out of the same judgment and award. And this honorable court has already been condoned of 6-7 LA appeals, and appeal also have already been admitted, Lordship. Lordship, one quarter 10 lessons were Lordship. 1 bigger, 2 quarter 10 lessons were acquired by the government for the construction of building.
So, in this application, we will issue notice.
Lordship, already government equal government of Assam and Railway, Lordship. I think order has been, one order is there, Lordship.
No, that is in a different case.
But appeals, those appeals have been arisen from the same judgment and award.
Maybe, but whether the respondents are same.
Yes, the response same, Lordship, shown in the cause list, Lordship.
Maybe, but they may not be aware of filing this IA, filing this case.
They have taken a photostat copy today itself from us.
Maybe it does it mean that they have
Lordship, one order passed by this honorable the condemning delay of 403 days. Others analogous appeal have already been condoned, Lordship, and appeal also admitted. One order, Lordship, Lordship.
Yes, Mr. Gogoi, you are appearing for?
I am Lordship.
Respondent number 3.
Respondent number 3. Today itself we have received a copy, Lordship. Just.
It is given.
No, we will issue notice to the other respondent, 1 and 2.
One is that
We today itself, just.
Okay. Heard me, sir?
BC Decca, Lordship.
BC Decca, learned counsel for the applicant. And also heard Mr. Gogoi, learned
I'm TR
government advocate for the respondent number 3. This interlocutory application is preferred for condonation of delay of 403 days in filing LA appeal against the judgment and order dated 21/12/2019 passed by learned district judge Gwalpara in LA, which indicate reference case number 21 of 2013. Let notice be issued to the respondents returnable in 4 weeks. Step upon respondent number 1 and 2 be taken by registered post with AD and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 3. Since Mr. Gogoi, learned government advocate, appears and receive notice on behalf of respondent number 3, however, extra requisite copy of the petition be furnished to him during the course of the day. Please the matter after 4 weeks.
48.
May it please your lordship. Your lordship, this IA is for condonation of delay and there is a delay of 49 days.
Okay, we'll issue notice.
Okay.
Chamber.
Much.
49.
After 4 weeks.
If please your lordship, this I has been filed under section 5 of the Limitation Act for condonation of delay in filing the connected FAO case number 5260 of There's a delay of 54 days.
Okay, let notice go at this is this. Same order.
$52.
Yeah, I believe Lordship. Lordship service on respondent numbers 1 to 6 is complete, my lord. And 7 is awaited, my lord. And on respondent number 8, my lord, some Subal Deka received on behalf of Genex Parivan, my lord, already taken in my lord flag A, my lord. Respondent number 8. And LCR received, my lord.
Two 2022 matters.
It may be fixed for hearing, my lord.
Why?
My lord, service is most
Other
complete, my lord.
respondents in respect of
Only
7,
7, my lord, awaited, my lord.
then
My lord, then after
without service of notice, we will hear the matter. Thereafter, the other party he will come and say that no,
Yes,
without
my lord.
hearing me,
That's the problem.
the judgment was passed.
Let them appear, my lord.
Heard, madam.
L. Sharma.
L. Sharma, learned counsel for the appellant, and Mr. M. Khan, learned counsel for the respondent number.
1 to 6 except 3 lordship, 3 expire.
1, 2, 4, 5, and 6. 5 and 6. Office note dated 13/8/2024 indicates that AD card in respect of respondent number 3 and 8 has been received back.
By some Krishna Boru. Krishna Boru is
Our respondent number 3 died.
Died. All the family members are already
wife of
represented.
respondent number 2. Wife of respondent number
Already
2. my lord.
all other family members are already in the parties.
Yes, ma'am.
That's why lordship substitution is required.
Okay. Where is the acknowledgement?
Leg A.
AD card लेता कौन? AD card ये कुछ नहीं. User process. Itu AD card itu not receive back. Itu receive back. AD card receive back. ये तो ना AD card. You can do I notice special to the user process.
AD card is not there, my lord. Only process by the process server we have received by the section man.
And by my user process. User process service secretary office. Take a plenary purpose. I take a step to notice for
I want to prefer the next session, like A. Like it here. We have played it. This one is like the situation.
Okay, you take fresh step upon respondent number
Eight, my lord. Yes, my lord.
8 and 7.
Seven is awaited, my lord.
Hmm?
2 years already.
7 awaited.
Yes, my
There are
lord.
already 2 years left.
No, my lord.
So recessal is the matter after 4 weeks. Awaiting service report upon respondent number 7.
Seven.
And fresh step be taken upon respondent number 8.
Eight.
By registered post with AD and also by usual process within a week from today.
Oh, bless you.
53. 53.
None appears for the applicant on call. Recessal is the matter after 1 week.
Why would it be schools appealing?
9.
Timing 46.
Your lordship,
Still late.
yes, lordship. Fourth one, lordship.
Okay, as agreed by learned advocates of both sides,
Lordship.
recessal is the
Lordship.
matter on.
Lordship, one small submission, Lordship. Lordship, on 16th August, day after tomorrow, similar nature matter, similar.
Okay, 16 hours.
On item, Lordship, if Lordship may connect it with item number 29, Brahmaputra Union of India.
Item number
29. Lordship, I'll just mention tell the quote, the case number as well.
The learned counsel for the respondent number,
Sole respondent.
sole respondent submits that connected matter is being listed on
16th August, item number
16 of
29,
August, being I number or
241, 2000.
I number 41,
241,
241.
2023.
Accordingly, it is provided that recessal take this matter with the I number so and so and so.
Lordship may kindly direct the respondent to provide us with the copy of the interlocutory application and the appeal. We have not received a copy
Okay,
of.
provide a copy.
Since the matter is listed day after tomorrow, Lordship may kindly direct to provide today or day after tomorrow.
If available with her, only she can, only then she can
Soft copy
provide
would
it.
also work, Lordship.
Pardon?
Soft copy, Lordship, soft copy, if the council may provide me the soft copy.
Sorry, she will provide copy. I don't know whether she will provide soft copy or
Lordship.
this
Much
is unusual pair.